So what is the impact of the Chevron decision? I think it will be positive. Seems like it would be positive. But Rick Esenberg from the Wisconsin Institute for Law and Liberty joins me on the Middleton Ford hotline to maybe pick through this decision a little bit more closely. What will it do? What won't it do? Great to have you, Rick. Thanks for joining me.
Well, thanks for having me, Vicki.
So this is, it's an unqualified positive when you have the Supreme Court say that the courts get to decide what the meaning of the law is. You don't just defer to a bunch of bureaucrats to determine what the meaning of the law is. They're bureaucrats. They're not lawyers. They're not judges. And so immediately, what do you think the impact will be from this decision?
Well, I think the impact will largely be in the lower courts. For a while now, the court has, and one of the things I think we should clear up at the outset is that you hear a lot of things, you see a lot of things on X about people saying, well, courts don't know how to resolve these difficult technical questions. But what this case involves is not technical questions, but legal questions. And under an old case called Chevron, the rule was that agencies were permitted deference as to their interpretation of the statutes that they administered. And so basically, if there was a dispute about what a statute meant, courts would have to defer to the agency's interpretation of the statute as long as it was permissible, as long as it wasn't, utterly crazy. And what the court has backed away from that in recent years with respect to what they call major questions, really, really important questions about statutes. And what happened in Loeb Bright on Friday is the court moved away from that and said, look, courts are the ones that have the expertise in construing ambiguous statutes. Yes, we'll still give due weight to the agency's technical determination, but we are the ones who are charged by the Constitution to say what the law means. And we're going to do that with respect to all legal questions. And that's going to have a significant impact, maybe not in the Supreme Court, maybe not in the biggest profile cases, because they were already doing that under the major questions doctrine in a lot of those cases. But in just a lot of the litigation that happens in the lower courts over important but not earth-shattering
right.
questions.
But that's where Rick, it's where it matters. Everybody's not getting to the Supreme Court. You're not even necessarily getting beyond the lower courts. That might just be where you start and where you end. And so the case was about fisheries. And the fishermen were told, or the fisheries were told, they had to put bureaucrats and pay them on their boats to make sure compliance with whatever act it was. And the court said that the question of whether or not that was okay wasn't up to the government. Congress didn't mandate it. It wasn't up to some agency in the government. The court should have determined whether or not that was okay. And so honestly, that's kind of a big deal to have the courts
big deal
punt.
If you're a fisherman.
Well, sure is. And these are the kinds of cases we're talking about. Because usually it can't be totally crazy, but that's kind of crazy to say, oh, yes, we read this regulation to say you not only must comply by putting one of our employees on your boat, but you also must pay this person $710 a day, or else you're in violation. That's kind of nutty, if you don't mind my saying. So they let him get away with a lot, even though technically speaking they weren't supposed to. But so many years ago, to give the courts permission to just punt on something that was the court's responsibility, and that was determining what the law meant in the face of ambiguity. I think that was shocking we ever did that.
Yeah, and what's important about this is, if you look at our constitutional system, go back to, nobody teaches civics anymore, but back when they did, go back to what you would learn in high school, or maybe even before high school, that our government is one of divided powers. We have separation of powers. There are checks and balances. And we have the legislature, they make the law. We have the executive, they administer or execute the law, and we have the courts. They resolve disputes about, what the law means. And what the court did in Loper Bright is go back to that, go back towards our constitutional settlement on these questions of what happens when an agency and somebody who's being regulated disagree on what the law means. So from now on, courts get to decide the case. The agencies don't get a big, heavy thumb on the scale. And I think that that's all to the good.
Well, I do too, because it should deter the crazy, the sort of abuse of the ambiguity in a regulation or a rule. It should deter that a bit, at least. Minimally, though, it will allow more people access to relief through the courts. I'm hoping more of the first happens so that less of the second has to happen. But at least you're not just going to, have a lawyer tell you, well, gee, Jim, I'd sure love it if I could help you. But what the court is going to say is that they're just simply going to defer to the agency. So I'm just not, I just don't feel right taking your money on this case. It's not fair, doesn't make any sense, but, it's not going to go your way, probably.
Yeah. And, we hear a lot of things about, now the sky is going to fall and we're going to have no more environmental regulations. And, it's going to be the wild, wild west out there. That's not true. And this could cut both ways ideologically, depending upon who is in control of the agencies. And the one thing that we need to keep in mind is that Wisconsin abandoned this type of deference a number of years ago in a case called Tetra Tech. And, we still have functioning regulatory agencies. It's fine.
So
no
weird.
Horrible things happen. So I think we'll be fine.
Yeah, no, because did you need technical expertise to determine whether or not someone should pay a government employee $710 to be on a fishing boat? No. You did not need technical expertise for that. You just had a bureaucrat who made the determination that this is how they wanted to force compliance with an interpretation of a regulation they didn't have the authority to make. And you're right. In Wisconsin, we had the Tetra Tech decision in Wisconsin, which said, I think the legislature couldn't delegate its authority or the governor couldn't delegate his authority. We actually had that in the Palm case in a way as well, because Tony Evers wanted to delegate his authority as an executive to Andrea Palm during COVID. So will this have any impact as a case at all on what Congress routinely does? And that is delegate its authority with regard to the budget, with regard to rulemaking. I mean, they pass a law. Think of Obamacare. It's 1,500 pages. The rules to implement Obamacare are 1,800 pages. So will that rein that in at all?
Well, in a way it will. I mean, I'd still like to see some return to a non-delegation principle, and that's not quite this, but it will nevertheless move us in that direction because I think what's been happening is, Congress passes a general law and then they wash their hands of the situation and they say, well, let the agency take care of it. And when the court's deferring to the agency, they basically put them in the driver's seat. And now, the courts are going to take a hard look at claims of legal authority. And if they find that the agency is doing something that they cannot conclude Congress authorized them to do, then if the agencies want to continue to do that, if it's a good idea, they need to go back to Congress and get Congress to pass a law. And so I think that this is one step. There are other steps needed, but it's one step to getting Congress back to the point where they exercise their responsibility to be the branch in which the legislative power is vested and to make decisions that they need to make. And if they want regulation to proceed in a certain way, then they should make that clear. If it isn't already.
On the issue of non-delegation, it is a shame that I just heard you say it's not quite a non-delegation principle coming out of this case, because I was kind of hoping it was. But if it informs that process at all, or has an impact on cases in the future, that they will go back to this case and say, you know what, we began down the logic, we began using this logical pathway of non-delegation, and it seems to apply here or not. Where is the congressional version of JCRAR? We have this wonderful committee in Wisconsin. I don't say that very often, but we have a wonderful legislative committee called the Joint Committee for the Review of Administrative Rules. And it's probably the most boring committee to sit on, but it's also one of the most important. Where is that process in government?
Yeah, I mean, I think that as a general matter, if you look at this question, the question of judicial deference, if you look at the question of non-delegation, we really don't have that principle right now under Wisconsin law, although I wish we would. But we have procedural safeguards. So we're supposed to accomplish the same thing. I think that what you need to do is you need to get Congress involved again. And to be sure, Congress can't specify everything. There's going to always have to be room for some type of agency discretion. But what we don't want is a situation in which Congress passes a law and, tells a bureaucratic agency, go and do good, and then washes its hands of the matter. And I think that as a practical matter, Chevron, particularly in non-major questions, had that effect. And I think that removing that, not giving the agencies that thumb on the scale, I think will have the practical effect of even though the Loper Bright court, said, well, if they delegate, they delegate. But I think that the fact that the judges are going to take a hard look at this and ask whether or not someone has the authority to do what they're trying to do, hopefully will have the effect of re-engaging Congress again.
I hope so too. And that assumes that they follow the lead of this court. You can just simply ignore the court, as the Biden administration has done multiple times. But it does seem to me that there are probably a big enough handful of people in the legislature itself, in Congress, who say, maybe we need to take better control over the law, the rules that implement the law. And, who knows? We could have a bicameral version of Wisconsin's JCRAR. It could happen in Congress. Not in my lifetime. I'll probably be dead before anyone thinks of it, but still just wanted to throw it out there. Rick Esenberg, it's a good thing, though. It is no doubt going to help people.
I think so. And I think anything that strengthens our separation of powers, strengthens our checks and balances, is a good thing. It advances democracy. And there's been a lot of people that have been waiting a long time for the end of Chevron deference. And finally on Friday, we got it.
Good to have you on the program. Thanks so much for jumping on today. Rick Esenberg, Wisconsin Institute for Law and Liberty.